Hello, this is Attorney Pendergraft, the host of the Real Estate Attorney Podcast. And for today, I'll be discussing what I think real estate investors should know about revocable living trusts. Disclaimer, this is legal information, not legal advice. For legal advice, contact an attorney that is licensed in your jurisdiction. I'm only licensed to form trusts in Maryland and in DC. So what I talk about here applies, even though what I talk about here applies to many jurisdictions, there may be exceptions in yours. So please consult with an attorney in your jurisdiction. That said, you can download the mind map to this presentation at tpf.legal/RLT. It's short for Revocable Living Trust. So tpf.legal/RLT. You can download these slides. And let me know what you think of them. I don't usually do this. I generally prepare slideshows. So I'm interested to see what people think of this new format. So what I'll be discussing in part one is what I want investors to know about revocable living trusts, and in part two, why you may want one. So let's get into it. Number one, they're super easy to create. At a minimum, you need a revocable living trust document. No state registration is required, and that's it. So when preparing trusts, I also like to add in documents that make it easier for my clients to use. But all you need at a minimum is a revocable living trust document. There's no state registration like articles of incorporation or additional things that need to be filed. Number two, on what I think investors should know about revocable living trusts. Basic definitions. So, living trust, let's define it. Living trust is an agreement where a trustee holds legal possession for the benefit of the beneficiary while the person is alive. Settlor, that is the trust creator. In many cases, that will be you. The trustee, that is the asset manager. That can be you or an attorney such as myself or a friend of yours, whoever you want it to be. Beneficiaries, generally, the beneficiary is you, or it can be whoever you want it to be. It can be you and your kids. It can be just your kids. It can be your wife, whoever you and your wife, whoever you want it to be. All right, number three, you must title real estate in the name of the trust. For example, if you're doing a deed should read, for the grantor, let's say Brian Pendergraft, trustee of the XYZ Street Revocable Living Trust. So that is one way to, and of course, the name of the trust I came up with was the XYZ Street Revocable Living Trust. Number four, the benefits of being your own trustee. So it's very easy to maintain. If you're your own trustee, you do not need to file a separate tax return or obtain a separate trust return. All income generated by the trust can be reported on your personal IRS Form 1040. All right, number five, benefits of an attorney trustee. Number one, privacy. It's because the trustee name is public, or the trustee deals with the public, and you can hide ownership by not being the trustee. However, real estate transactions are public record, so you must form a trust you must use a trust at the time you acquire the property to maintain anonymity. You do not need to an attorney trustee for this, but, and this brings me to point number two, attorney-client privilege, which is like super privacy on steroids. So suppose your trustee receives a subpoena about your trust because of foreclosure, debt collection, IRS, child support, tax collection, bankruptcy, criminal matters, government enforcement action, etc., etc. An attorney is duty bound not to disclose any information that is contained in any client communications, whether oral or written. This is a strong legal precedent for confidentiality protection that you cannot receive from a non-lawyer. All right, number six, no liability protection. In most revocable living trusts, the beneficiary is yourself, and your interest in the revocable living trust is considered personal property that is subject to a judgment. The trust itself does not limit liability. However, you can separate liability from, it says from, let me fix this, from yourself and a trust if someone or some business or something other than you is the beneficiary. So that is how you would separate yourself. But you may not want to do that, or you may. Who knows? Talk to an attorney. See what's best for you. So on to part 2, why you may want a revocable living trust. Number 1, many conventional lenders do not like lending to business entities such as LLCs. But they will lend the trust of a person's beneficiary. So if you're looking for conventional financing, many will lend to trust. So that is one way for you to go about hiding your name and still being able to get conventional financing. But of course, speak with your lender and make sure that they're okay with this. 2, you may want to keep your assets secret. If you have a bunch of assets in your personal name, you are a target. An inexpensive asset search can help a money-hungry attorney such as myself determine if you're worth suing. And another example is, well, and of course, if it's not in your name, these assets will be harder to find. So, and 2, I had a or 2 of part 2. I had a situation where a tenant did a public record search and found out who their landlord was in order to harass them. A landlord contacted me about this. So I think that this may very well happen a lot. I mean, it's only happened to me once, but who knows? Maybe this has happened to you. Number 3 of why you may want a revocable living trust. Many hard money lenders will only lend to an entity such as an LLC or a trust. So many hard money lenders will only lend to an entity such as a LLC or a trust, and sometimes forming a revocable living trust is preferable because, and this brings us to number 4 of why you may want a revocable living trust. Your state may charge an outrageous amount of money to form and or maintain business entities. Forming an LLC can cost anywhere from $50 to $800, depending on the jurisdiction that you're in. I've estimated that the maintenance cost to properly maintain an LLC is $1,000 to $2,000 per year. Because revocable living trusts do not require state registration and business filing fees, the cost to maintain a revocable living trust is generally cheaper than it is to maintain a limited liability company or other more expensive entities. Number 5 of why you may want a revocable living trust, and I have this as avoiding probates, incapacity, and estate planning. In the event you become incapacitated and or die, the assets held in your personal name will require maximum court supervision / intervention to manage. This costs a lot of time and money to pay guardianship and or probate attorneys, depending on whether you're incapacitated or if you, let's say, died. Whereas if you have a trustee or a successor trustee, they can continue to manage the assets with minimal court intervention and care for you and your dependent and your beneficiaries, depending on how the trust is drafted. So very helpful this is particularly very helpful for investors that hold real estate in multiple jurisdictions. So you won't be, so your, heirs won't have to just fly around to each state to handle your affairs. I mean, or at least it will be minimized if they have to. Number 6 of why you may want to revocable living trust: management by absence. Settlor can have his trustee handle all affairs regarding the trust while he sits back and collects checks. Your trustee can collect rent. They can sell the properties. They can appear in court, represent the trust. So make sure you have a trustee that you can trust. So you could so they could write you those rent checks. That being said, you want to make sure you have one that you can trust, so they're not, writing themselves checks and then fleeing the country. Another reason why I think attorneys, trustees are good. But hey, if you have a really good friend or, spouse or a loved one or someone you can, trust to be your trustee, then, again, this is a great way for you to reap the benefits of your assets without having to even touch them. And number 7, it is revocable. So you change your mind and you don't want your trust anymore, well, just revoke it and it's done. That's why it's called a revocable living trust. Who knows, maybe next presentation I'll talk about an irrevocable living trust or something so you guys can see the difference. Anyway, so I am done here. Thanks for watching. So if you need a revocable living trust or an attorney trustee, consider choosing me. You can visit www.tpf.legal to schedule a time for me to call you within 24 hours. Thanks for watching.